for the Conservation Commission and the Wetlands Agency to order at 6:30, April 8, 2021. Roll call.
Craig Palmer.
Here.
Tom Murphy.
Here.
Ned Dalton here. Luigi Cavallo.
Here.
Joe Paletta. George Tupont. Pierre Moran.
Here.
Charles Bellevaux.
Here.
Bill Mahler. Pat Tierman.
All right, we'll see Charles Belleville for Joe Paletta, correct?
And Luigi. Luigi's.
No, Luigi's good. All right, anybody from the public wishing to speak?
Yes.
Is there anybody from the public?
Yes.
Yes, Mr. Chairman.
Okay, go ahead.
Thank you. Catherine Camera, 31 Cottage Place. I just want to say that I'm really grateful for Tom Murphy's comments at the last meeting. It was nice to hear somebody that passionate about something and really want thorough looking. Not that I don't think that this commission, I've told you many times before, I think you do a great job. I have a lot of faith in the commission, but just he made some comments that were long overdue for the public to hear from somebody on a commission. So I do want to thank him for that. That's all I wanted to say. Thank you very much, gentlemen.
Thank you. Anybody else in the public? Anybody else in the public?
No, Mr. Chairman.
Okay. We do have a public hearing. The ground rules, Musa, weren't in the secretary's package. I don't know if you could read them, or I don't have a copy of the ground rules.
Ned doesn't have it?
Not in his package, no.
Oh, no, I don't have it. I don't have it, but I can get it from my office. Just 1 second.
Wait 2 minutes.
We can do acceptance of the minutes anyways. Did everybody receive the minutes?
Yes.
Yes.
Yeah. Any questions on the minutes?
No.
No questions. Can somebody make that a motion?
I can make a motion. We accept the minutes of the regular meeting, March 11th, 2021.
Second.
Motion made and second. Any questions on the motion? All in favor, raise your right hand.
Aye.
Aye.
Aye. Any abstentions? No. Any against? No. Motion carries. All right, we'll go to the public hearing. I think we're just waiting for Musa to get the. Dave, can you look at my old stuff over, see if there's a thing about this. I might have one over there.
Oh.
Sorry about that.
Okay.
Okay, we have two ground rules. One is for public hearing. Ground rules, Conservation Commission and Inland Wetland Agency. The applicant or his representative will make his formal presentation to the commission stating the proposed regulated activities, the wetland impacts, and the alternatives which were considered by the applicant. 2, all comments, discussion, and observations shall be made through the chairman after proper recognition by the chairman. This is necessary to ensure that only one person at a time speaks on any issue, thus making it easier for everyone to understand and for clear legal transcription. 3, all persons addressing the commission shall begin by first clearly stating their name and address for the record. If necessary, the person may be asked to spell his name for the record. 4, following the presentation of the application, the Conservation Commission and Inland Wetland Agency will ask specific questions of the applicant. 5, after the commission has asked its questions of the applicant, I shall then allow any members of the public who wishes to speak either in favor of this application or against it to address the commission. 6, I shall then allow the applicant to respond to the comments of the members of the general public. 7, I shall then allow any members of the general public who wish to present any additional information or clarifying discussion to do so. 8, I shall then provide an opportunity for the applicant to respond to these additional remarks if he or his representative so wishes. 9, the Conservation Commission and Inland Wetland Agency has 35 days from the date the public hearing commences to complete the public hearing. The commission may ask the applicant for a 35-day extension of the public hearing period if the commission requires any additional information or wishes to schedule a site walk to observe the situation for themselves. 10, the Conservation Commission and Inland Wetland Agency has 35 days from the date when the public hearing is closed to render its decision. And then there is, okay, there is another ground rule. This is a web-based virtual meeting, so we are operating under the following procedures. This session is being recorded, both video and audio. Mark Massoud, the land use administrator, and Michael Simmons, the town's IT director, will be the meeting administrators. A link to the video/audio will be posted to the town's website. Most people attending this meeting will be muted. The commissioners and staff will not be muted. However, in order to minimize disruptive audio feedback, all participants should keep themselves on mute until ready to speak. Individuals will be unmuted at the time they are recognized to ask a question or make a presentation. Presentations may be made by applicants and their agents when appropriate and permitted by the commission. Other attendees will be permitted to speak only during the public hearing portions of the meeting. Commissioners and staff will generally be keeping video of themselves on throughout the meeting, unless they are attending via telephone only. Applicants and members of the public should feel free to leave their video on or off. However, they will be asked to turn on their video when speaking. A picture tells 1,000 words and can be useful in conveying your meaning. If video is not available for you, you will not be precluded from speaking or providing public testimony. During public hearings, individuals desiring to speak will be asked to state their name and give their home address. We will read the public hearings rules at the start of the first public hearing of the meeting. Please use the chat feature or the raise your hand feature for the meeting administrators to know that you have raised your hand to speak. If an applicant or agent needs to submit additional documents to the commission, which was not distributed in advance of the meeting with the rest of the materials, the application will be continued to the next meeting so that the new documents can be made available to the public. Members of the public may only speak during a public hearing. If a member of the public speaks outside of a public hearing or creates an audio or video disruption, they may be manually ejected from the meeting upon recommendations of the meeting administrators or the chair.
Thank you, Mr.
You're welcome.
Public hearing 1, application 2021-2 of the Town of Watertown Department of Public Works for replacing an existing culvert at 152 Falls Avenue, Watertown. Is Paul there?
Yes, Mr. Chairman. Good evening, Mr. Chairman, commission members. For the record, Paul Benevich, Watertown Town Engineer, representing the applicant, the Watertown Department of Public Works for replacement of an existing deteriorating 7 by 5 foot arch corrugated metal pipe under Falls Avenue near the location of House 152. This part of Falls Avenue was constructed over half a century ago in 1967. And there's other pertinent corrugated pipes and catch basins that we're going to also remove and replace. This culvert was originally part of a relining application that you approved a few years ago, but that would only solve the structural issues with the corrugated pipe. It's still undersized and wouldn't handle more than a 10-year storm, even if we did reline it. So this proposal is to remove that and replace it with an open bottom 3-sided precast concrete culvert, 10 foot wide, 6 foot high with 1 foot of stream bed replaced in the invert of the pipe. I have a list of all the impacts that I submitted. Do you want me to read those into the record, Mr. Chairman?
If you don't mind, Paul.
Yes, that's fine. All right, number 1 through 3. there were 3 items removed from regulated areas. Item 1, 13 cubic yards of stone rubble retaining wall on the west side of the existing culvert. 8 cubic yards of stone and earth stream bed on the west side of the existing culvert or upstream side. 9 cubic yards of stone and earth stream bed on the east side or downstream side of the existing culvert. Now, at the site walk this evening, the commission requested, they asked me about this rubble stone wall on the west of the wetland inlet area on the uphill side of the culvert. We'd be asking to remove that, add that additional removal to this application, if I may. That would be about 9 cubic yards of stone removal from the regulated area. Total excavation from the regulated area would be 39 cubic yards, and the wetland area impacted would increase slightly from the 400 square feet I originally submitted to probably another 40 square feet or right around 1/100th of an acre of regulated area impacts. Items removed in the upland review area include the 58 lineal feet of the existing corrugated arch metal pipe, 8 cubic yards of the concrete head wall on the downstream end, 15 cubic yards of stone rubble head wall and wing walls on the upstream end, and the pertinent piping, 62 lineal feet of 12-inch RCP, 20 lineal feet of 18-inch corrugated metal pipe, 77 lineal feet of 24-inch corrugated metal pipe, 76 lineal feet of the existing 8-inch water main, which will be rerouted around the proposed culvert, 4 catch basins to be replaced. Total excavation for these items, 260 cubic yards. And along with, let's see, I had some of these quoted in cubic yards. The total excavation in the upland review area is 283 cubic yards. Proposed regulated area impacts include number 1, replacing the stream bed material in the inlet and outlet channels, 30 cubic yards. installation of a Gabian retaining wall in the west inlet channel. And we're going to increase that, or ask to increase that from 30 cubic yards, an additional 24 cubic yards. I estimated a total of 54 cubic yards of Gabian retaining wall. Excavation of 12 cubic yards and deposition of 11 cubic yards of earth fill for the installation of 18 lineal feet of 8-inch water main and 5 lineal feet of 12-inch ductile iron sleeve. That's for the relocating the water main on the west side of the culvert per Mr. Caterino's request that we don't go under the culvert. Upland review area impacts of the installation of the new box culvert, 50 cubic yards of precast concrete and 45.6 cubic yards of stone stream bed material. Excavation of 325 cubic yards of earth material and deposition of 80 cubic yards of gravel and bituminous concrete pavement to cover the culvert. Second item, installation of 1 concrete head wall on the west side and 1 concrete head wall with wing walls on the east side for a total of 50.5 cubic yards of concrete, reinforced concrete. Item 3, installation of 45 lineal feet of stone Gabby and wing walls. We would update that another, I think it's 35 feet, so a total of 80 lineal feet of stone Gabby and wing walls, and a total of, let's see, I guess about 300 cubic yards of Gabby and wing wall. Installation of 97 lineal feet of 18-inch high-density polyethylene pipe with the deposition of 60 cubic yards of earth fill for that installation. Installation of 84 lineal feet of 15-inch high-density polyethylene pipe and deposition of 35 cubic yards of earth fill for that pipe installation. Excuse me. Installation of 4 catch basins with deposition of 10 cubic yards of earth fill for that installation. Installation of 82 lineal feet of 8-inch water main, 2 gate valves, and 15 lineal feet of 12-inch ductile iron sleeves. Excavation of 60 cubic yards of earth material and deposition of 58 cubic yards of earth fill for that construction. And last, installation of 90 square feet of bituminous concrete pavement, 120 lineal feet of bituminous concrete lip curving, and 250 square feet of concrete sidewalks and ramps, a total of 20 cubic feet of concrete for the sidewalks and ramps. So the total excavation for the Upland review area items, 385 cubic yards. Total deposition of, let's see, yeah, it would be total deposition of earth gravel fill for above items, 289 cubic yards. Total deposition of concrete for above items, 124 cubic yards. And with that other, let's see, 95 cubic yards, 300 cubic yards of deposition of stone Gabian walls. Total Upland review area would only slightly increase. It's probably just rounded off to 0.125 acres, just over 5,400 square feet.
Paul, there was nothing included in our pack. There's no site map or anything in our package of this, right?
No maps?
Well, a drawing of what we're doing, you know, what you're doing. Usually we get some type of drawing or something. I don't have anything. Maybe I just missed it.
It was in last month's package.
Yes, Mr. Chairman, I sent a copy of like a set of plans for every commission member at the last meeting.
Okay,
actually.
All right.
Yes.
Yeah, sorry.
We did do a site walk there tonight. Any other members of the commission have any questions on this?
It needs to be done. Tom Murphy, needs to be done. So
Okay.
I think adding that extra work into it makes sense at this point.
Right.
Let's get Mr. Chairman, if I may, I'm sorry to interrupt, but I forgot that we were talking about that head wall.
Right.
On the wagon wheel court on the north side of that existing 48-inch RCP that's falling apart. I would request that we put that as part of this application, repair that. I estimate around 2 cubic yards of concrete needed to do that work.
I agree. Ned, did you have a question?
That was what I wanted to bring up.
Yeah, that's good.
Musa, do you have any comments or additions?
No, Mr. Chairman, this is something that has to be done. And I look at, because you determined that this is a significant activity, I was looking for any alternatives feasible and prudent alternatives. One is that do nothing, which is not an option because there's a problem, they have to fix it. And the second alternative is to build a bridge, which is not prudent for this project. And therefore, what is proposing in front, what is the proposal saying in front of you is the most reasonable alternative to do this project and finish that and get rid of that problem.
Thanks. I don't know, Moose, is there any of the neighbors on here tonight or no?
We received all the green cards from the neighbor that Paul sent it to them.
Okay.
And there is nobody in the public who wants, I'm sorry?
Catherine, Dan, and Nancy.
Yeah, none of those are neighbors, Mr. Chairman.
Nobody from the neighbors are here to talk.
Okay, so there's nobody from the public to talk on this area. All right.
Make a motion to close the public hearing.
Second.
Motion made and second. Any questions? All in favor?
Aye.
Aye.
Aye. All opposed?
Oh.
Any abstentions?
Thank you, Mr. Chairman.
Motion carries. Thank you, Paul. Old business. Application 2021-2 of the Town of Watertown Department of Public Works for the replacement of existing culvert at 152 Falls Avenue, Watertown, Connecticut. So that can be modified to add that additional work on Wagon Wheel Court?
Yes, if the commission wants to make a decision tonight, you can do subject to do the modifications.
Okay.
And also standard conditions.
And a water handling plan. You want? Yeah.
Yes.
Make a motion to accept the application 2021-2.
Accept or approve?
Approve.
Because you accepted this last month.
Yeah, sorry. Make a motion to approve application 2021-2 of the Town of Watertown Public Works for replacement of the existing culvert at 152 Falls Avenue with standard conditions plus the additional work on Wagon Wheel Court.
And one other thing, water handling plan to be submitted to an officer for review and approval.
And what Musa said.
Second.
Motion made and seconded. Any questions on the motion? All in favor, say aye. Raise your hand. Aye.
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 All opposed?
Do you want to read their names, Mr. Dalton? The commission names to see who voted?
Yep. Greg Palmer.
Aye.
Tom Murphy.
Aye.
Myself, aye. Pierre.
Aye.
Luigi Cavallo.
Aye.
Charles Belvo.
He's muted.
I think he's muted.
Frank,
Can you unmute?
is Charles muted?
He appears to be. Maybe he could raise his hand, Musa, or something.
It's not working.
He's self-muted.
He's self-muted.
Charles, you should unmute yourself.
All right, we have.
Okay.
No, he's still.
That's okay. The motion passed.
No,
with...
it passed anyway. Motion passes. Thank you.
Thank you.
2, notice of violation issued to the owner, 30 Jericho Road, Watertown. And 3, notice of violation issued to the fire district concerning regulated activities conducted on district property on Judd Farm Road, Watertown. Any update, Moose, or no?
Mr. Chairman, at the last meeting, you asked me to ask Attorney Jessel to see if there is any update regarding this.
Yes.
We sent out an email to Attorney Jessel. Unfortunately, he had a knee surgery and he didn't recover totally to come back to the office. and he's not back basically. And hopefully by next month's meeting, he will be back in the office, and I will talk to him to see if there is anything happened since last time.
Okay, so we just need a motion to table these.
You just need a motion to table item 1 and 2.
Correct.
Make a motion to table items 1 and 2.
2 and 3.
2 and 3.
Excuse me, 2 and 3.
And we need a second.
Okay.
Motion made in second. Any questions on the motion? And that'll read the roll.
Craig Palmer,
Aye.
Tom Murphy,
Aye.
myself, aye. Pierre Moran,
Aye.
Luigi Cavallo,
Aye.
Charles Bellavo,
Just put him down as
Charles is muted.
abstained.
Mention, right?
All right, motion carries. Thank you. 4, discussion application review process by the agency. Moose, I see in our packet, there was an inland wetlands engineering review checklist. Can you give us the highlights on this?
I'm sorry?
There was, in our package, there was an inland wetlands engineering review checklist.
Yeah, that is on the agenda. We will talk about it when we get to that item, yes.
All right. I don't know, does anybody else have anything under this from the commission? No other comments? No, there's no motion there, Musa, correct?
You can table this, or if you want to remove it or you want to keep it, you just need a motion to table.
That'll make a motion to table.
make a motion to table.
Second.
Motion made and second. Any questions on the motion? And that'll read the roll.
Craig Palmer,
Aye.
Tom Murphy,
Aye.
Ned Dalton. Aye. Pierre Moran, Luigi
Aye.
Cavallo, Charles
Aye.
Motion. New business application 2021-5 of Dennis and Rita O'Sullivan for the subdivision of a parcel of land into 2 building lots and construction of 2 single-family dwellings, associated driveways, on-site sewage disposal systems, and wells located on the northwest corner of Northfield Road and Smith Pond Road, Watertown, Connecticut. Musa, do you want to run through
Mr. O'Sullivan is here and he is presenting his application.
Okay.
Can I start?
Yes, Dennis, you can start.
Yes. Thank you. The reason for my coming is...
Your name and address?
I'm sorry. My name is Dennis O'Sullivan, and I live at 238 North Street in Watertown. I've lived there since about 1964. The reason for my coming here tonight is that in about 1980, plus or minus, my wife was looking to provide... I'm sorry?
Go ahead, Dennis.
My wife was looking to provide facilities for 2 of our children. So what she did was she went out and she purchased a piece of property on the corner of Smith Pond Road and Northfield Road. And we really didn't do anything on it for a number of years. She again bought it in about 1980. And then recently, we decided that what we were going to do is we're going to develop the lots and see if we can get the children to consider building a house there. So I think what you have is a map that I have prepared of the two lots. And there is some wetlands on the property. There is a brook that goes down on the west side, goes under Smith Pond Road. And then there's also a wetland area down the center of the lot. And what the map I have given you shows the wetland, which has a hatched area. And then I've shown you the 100-foot setbacks on both sides of those wetlands. Now, what I'm proposing to do is on the Northfield Road side, I'm proposing to build a house and install a septic system in an area that is not in the wetland and not in the setback area. In the other lot, I'm proposing that the septic system be located in the non-wetland setback area, but the house to be located in the 100-foot setback area. And if you look at the map on the west side, that area is all encircled with a stone wall. And there's also a building foundation that is existing. Now that foundation is quite old and it's up on the other side of a brook, but whether it was used for a home or it was used as a place for maintaining the animals that used to be out on the property, grazing on the property. The property on the west side, there's little or no trees on the area in between the stone walls. And as you get out near the Smith Pond Road, the stone walls becoming smaller and smaller because people are driving along, not people, contractors are driving along and helping themselves to stone and bringing it out and then dropping it someplace else. So what I'm asking you to consider is these two lots. Again, no septic is to be placed in a wetland or a wetland setback area. The house on Northfield is to be located, again, in a non-wetland and non-setback area. The only area that I am using the setback is for the house over on the lot on Smith Pond Road. I don't know if that gives you enough information about the overall project. I've done all the deep holes and the percolation tests, and I got approval, and I sent you a copy of that approval from the Bob Smith, the sanitarium. I've had the wetlands have been identified and marked by a wetland person, and I went out and I verified that all of the wetlands and the setbacks are all in place. All the markings that were done by the wetland person, and I'm looking for the sheet now on who that person was. think I gave you that. Huh?
Yes, it is Thomas Stanfield.
Say again, please. I'm sorry.
Thomas Stanfield.
Yes, Tom Sandfields.
Yes.
Yes, and he marked the wetlands, and I went out there, and the markings are still out there. I guess the question is, are there any questions other than what I've presented to you?
Does any members of the commission have questions on this? Any member from the commission?
Pierre Moran, I have a question.
Go ahead.
Hi, Dennis. On the line that goes through for the city of Waterbury.
Yes.
Is that something that needs a setback?
No, I've talked to the city of Waterbury. That's a very substantial precast concrete water line. That's been in there since before World War II. And it was part of the movement by the city to bring water to the brass capital for their defense work. And that goes down through the middle of town. It goes down Northfield Road all the way into the middle of town, makes a left-hand turn. I don't know if you know where Hawley Street is, but it makes a left-hand turn there and then heads down Main Street through the middle of town. There was I remember a number of years ago, there was some kind of a leak, a minor leak down by the ice cream business down in Oakville, entering Carvel, yes. Entering Oakville, and whether it was a hydrant or whether it was a tap off or a drain or whatever, I don't know, but I remember there was, the line was shut down. The city has about 4 lines that go from the reservoir down. And all of them are very important to the city and to all of the industries down there. And as a result, it reflects back up to other communities also.
Mr. Chairman, if I may interject, not to interrupt Dennis, but I'm familiar with this water situation. I did some lots years ago up on Bryant Road. I had the same thing. You just don't want to drill a well anywhere near this water line. You don't need a setback from it, other than staying out of the right of way itself, but you don't want to get a well drilled anywhere near this thing. That's the only restriction. That definitely don't want to do that.
Yeah, when I was doing the deep holes for the septic, I asked the city of Waterbury to come in, and they came in and they identified with flags all along the pipeline. And it just... Oh,
that was my other question. How did you locate? You get
yes, absolutely.
Okay.
Yeah.
Good.
Yeah, and I think some of those flags are still in place.
Okay.
Yes.
Anybody else from the commission have questions on this? Dennis, I don't see on the map any driveways. Are the driveways laid out anywhere?
I have those on a separate map, and generally, if you wish, I can submit those to you.
And this, Musa, we'll just make sure we're right on this. The lot on Northfield Road doesn't contain any issues with upland review or wetlands, correct?
Correct. So, Mr. Chairman, there is no activity proposed within the wetlands area.
Mr. Chairman, excuse me. I have one, besides the grading on there are no driveways shown. I did get a copy of these maps from Bob Smith, who Mr. O'Sullivan did submit those to. But these 2 cross culverts on Northfield Road, he's addressing the southern one with a solid 12-inch pipe that's going to be flowing by the septic system. But on the north side, this culvert near the northeast corner, it shows a minor, this water course continues on its running water. And and it has to be addressed one way or another with a pipe or something. Whether it's not wetlands, I don't really see how it wasn't picked up by the soil scientists as a water course, but it needs to be addressed.
The highway department was just out there and replaced both of those going across the road.
Yeah, I did go out there, and that's when I saw that, Mr. Chairman.
I did in response, I was aware of those, and I did in the past, and I have the documentation on it, I had asked that the town, since they're draining from the other side of the road, and in some cases, the town was involved with putting that drainage in. I asked the town, would they run collect the pipe and bring it down, collect a pipe on Northfield Road and bring it down to Smith Pond, where there's an existing drain pipe. And I was told that since these pipes are very old, the town is not going to do that. I'll have to handle it separately. And I did handle one, but I don't know that the other one is going to have any effect on, it's a little bit higher, and I don't think it's going to have any effect on the septic or the house.
Well, that is just something will have to be addressed through this is just the first time.
You can see that when you have a sidewalk, Mr. Chairman.
Right. Okay.
We should schedule a sidewalk on the complicated property.
Right, and this second house on Smith Pond, the only part that's in the wet or upland review area is the house, correct or no?
Correct.
Okay, so I think what the commission has to decide now is this a significant activity or not? So we can vote on that. Somebody want to, any thoughts on that, Musa? Do you agree that there's very
no, this is not a significant activity because there is some activity within Upland review area.
I just want somebody have somebody make that a motion so we can.
I'll make a motion to the application is not a significant activity.
Do we need a second?
Second.
Motion made and second. Any questions on the motion? That'll do the roll call.
Craig Palmer.
Aye.
Tom Murphy.
Aye.
Myself, aye. Pierre Moran.
Aye.
Luigi Cavallo.
Aye.
Charles Bellevaux. Abstain.
Just abstain. Motion carries. And I think the commission would like to do a site walk here, Musa.
I'd like to make a motion to do a site walk for this property.
Second.
You want to do it like today, like before the meeting, or you want to do it on Saturday?
Oh, before the meeting, if everybody else is fine with that, that seems because it's light out and it works well, I think.
Okay, 5 o'clock will be good.
Yep.
When are you going to do it?
The night of the next meeting at 5 o'clock.
Okay.
You've got to have a second on that motion, right?
Second.
May 13th, I think it is.
Yeah.
The night.
The motion's made and second. Any questions on the motion? That'll do the roll call.
Craig Palmer.
Aye.
Tom Murphy.
Aye.
Myself, aye. Luigi Cavallo.
Aye.
Charles Bellevaux.
Abstain.
Pierre Moran.
Aye.
Motion carries. And then let's make a motion to table this application.
Make a motion to table the application.
Second.
Motion made second. Any questions on the motion? Roll call, please.
Craig Palmer.
Aye.
Tom Murphy.
Aye.
Myself, aye. Pierre Moran.
Aye.
Luigi Cavallo.
Aye.
Charles Bellevaux.
Abstain. Motion carries. Thank you, Dennis.
Thank you. And look forward to seeing you out in the field.
Yeah.
Yes, we will notify you.
Okay, great.
Okay. Application 2021-7 of Dan Steroids for the construction of a single-family home on lot 49 located on the corner of Fern Hill Road and High Meadow Road, Watertown.
Yeah.
Moose, is there anybody here for this application?
Dennis Royce is here, yes.
Moose, I just had one question. There's been no permit, there's approved for this lot, correct?
Sorry?
There's no permit been approved for this lot, correct?
No.
I just wondered why all the trees were cut down and the driveway pad is in and it's all de-stumped.
Yeah, that's a good question. I think the applicant didn't think that there is wetlands on the property. And when I went there and did the inspection, and I noticed that some of the activities are within Upland review area. And I told him to stop working there, yes.
Right, there is a pond on that property.
Yeah, we didn't issue any zoning permits or any wetland permit, but they didn't think that there was wetlands.
Okay, so all the
I
work,
stopped them, yes.
all the work has been stopped, correct?
It's stopped, yes. They're not working there anymore.
And you're going to go and visit the site. I think it needs to be seeded in hay and stabilized till the permitted.
Actually, if I will suggest that you should go and see this too.
Right, but I want to make sure it's not for another month. There's a pond right below there. This should be hayed and seeded until approved, or hay bales.
Okay.
They've been working on it for the last 2 months.
Yeah, they put a silt fence there, but I will tell them to throw some seeds too.
And hay to stabilize it all pitches through the pond.
Very good.
Can I speak?
Yes.
Okay, Daniel Steroids, 30 Claremont Street, Oakville, Connecticut. I do have, Musa, I thought we do have a zoning permit over there. You told me I can put the stone in the driveway and clear the property.
You submitted the application. You don't have a permit yet. We didn't sign off on it. We just submitted an application. That doesn't mean that you have a permit. We didn't give you a permit to do it.
Okay, but I when I went to see you, I did tell you that I was clearing the lot, and you told me I can put the stone in for the driveway, and we put this all the
that was the only thing that we told you, to put the crushed stone on the driveway and stick out the location of the foundation. That's it.
Yeah, and you had me have my site guy put all the silt fence around the property, so the property is protected with silt fence.
Yeah, but we didn't.
And then you went up to inspect it. We called for inspection. You went up to inspect it.
And then I told you why you cut all the trees.
Yeah, well, that was my site guy. I guess he might have dug in just a little bit, but it's not way off the mark. If you guys would like to come and look. It's all marked out. Everything's been flagged. All the wetlands been identified. The pond is, the upper portion is flat, and then all the way down below is the pond. I mean, the lot's 500 foot long. And the pond is on the very bottom outskirts of the property. So the wetlands where it's flagged, what I measured, it was at 94 feet away. So it was in a little bit. And then
it's more than that.
I think the map is wrong. I don't know if you measured it or if you just went off the map, but I think Charlie Spat didn't do an accurate job with, because I measured from that last flag up and it was at 94 feet.
Yeah, we don't do the field work. We just review the plans that applicants submit. We just have to go by plans because this is drawn by a certified engineer and surveyor. I don't have equipment to go there and survey the property and to see exactly.
Right, I understand, yeah.
Anybody else have any questions on that application? We'll do a site walk here.
No, just schedule a site walk and we could take a first-hand look at it and, like I say, check the pond out, because I do drive by that every day and I see that.
Right. Tom, do you agree that some should be stabilized here for the next month until if it gets approved or not?
Yeah, because the pond is downstream.
Right, correct.
You know, down gradient from it. And, you know, the lot is fairly level to that point.
Right.
Yeah, and there is silt fence there. I mean,
on the backside,
pretty well, all the way around the property except for the front side. It's pretty well protected. There's no runoff going anywhere.
The silt fence up?
Silt fence goes all the way around the sides and the back side of the property.
Below the pond or above the pond?
Above the pond, on the flat portion of the land.
Gotcha.
Yeah. There's no disturbed area going down the hill.
Okay.
It's all on the flat portion with the silt fence there.
Any other members on the commission have any questions on this?
And would it be feasible to have Moose or somebody from the office go take a look at it and make sure the silt fence in place? I mean, I'm driving by at 30 miles an hour, so I'm not particularly.
Yeah, I think we.
I already checked the lot. The silt fence is in place.
Okay.
Yes.
And you've been up there, Moose, since he did all the de-stumped and graded the whole lot, or no? I think it should have a visit by Paul or you and see what else needs to be done for another 2 months here.
Okay, we will go there and see.
We can do that, Mr. Chairman.
Probably we ask him to throw some hay and cover that area.
Right. All right. We need a motion to table and for a site walk.
Make a motion, we table this application 2021-7.
Second.
Motion made in second. Any questions? Roll call, please.
Pierre Moran.
Aye.
Luigi Cavallo.
Aye.
Charles Belleville. Myself.
Aye.
Oh,
Hey.
yay, Charlie.
Hey, he's awake.
All right.
Tom Murphy.
Aye.
Craig Palmer.
Aye. Motion carries. Then we need a motion for a site walk.
Make a motion for a site walk to be the same day as the site walk that was scheduled right before our next meeting.
Second.
Like 5:30 p.m.
5:30 p.m. sounds good.
Second.
Motion made in second. Any questions on the motion? Roll call, please. Roll call.
Probably 5 minutes.
Craig Palmer.
Aye.
Tom Murphy.
Aye.
Take a while.
Myself. Aye. Pierre Moran.
Aye.
Luigi Cavallo.
Aye.
Charles Belleville.
Aye.
All right. And the only thing else we got on there is 3 online presentation of inland wetlands and water course regulators by our attorney, Michael Ziska and Hollerand and Sage LLP. Is that a video one, Musa?
Yes, Mr. Chairman. It takes probably half an hour, and it's very informative for the commission members to listen to that. Okay. Frank, can you put that presentation?
He represents numerous municipal, corporate, and individual clients involved in matters, among other things, environmental and land use counseling, drafting and amending ordinances and regulations, sitting and permitting proceedings, enforcement actions, and related litigation in state and federal court. He's going to be discussing wetlands law and procedure. Mike, when you're ready.
All right, thank you, Eric. I do have a PowerPoint, and I want to just emphasize at the beginning of this that the PowerPoint is just intended to be sort of a greatest hits of wetlands law. The materials that are provided in the book are much more in-depth, much more detailed. So I encourage you to read those of you that are particularly interested in the inland wetland section, I encourage you to read and review that section rather than to try to rely on or make notes from this PowerPoint and so forth. I specifically haven't put the PowerPoint in the book because I want you to review the materials. These are just to focus our attention on what
the only thing you screwed up was the year that you came up here and you said 1964.
All right, so the first item, the operative statutes, Connecticut General Statutes, section 22A 36 to 22A 45. It's not a terribly lengthy section, so those of you
you fiddled a lot with your papers.
Those statutes.
It
has been discussed.
Now this is, I kept this on because
municipal control of land use is entirely a statutory function. The courts have said that municipalities are not allowed to regulate land use any more than state law allows. And so when a statute says that a commission has to do something in a certain way, that's the way it has to be done. One difference with inland wetlands and planning and zoning functions are that municipal regulation is actually required. Although almost every town in Connecticut, I think every town in Connecticut has a planning commission, and all but I think 2 towns in Connecticut have zoning commissions or combined commissions. The statutes don't actually require commissions, planning or zoning commissions, to be created in any town, but wetlands commissions are obliged to be created. If a municipality fails to do that, then the state can come in and regulate on behalf of the municipality, but it's then entitled to charge the municipality for performing that function for it. And that certainly is something that I think most municipalities would not approve. So inland wetlands commissions may be combined with other commissions. And I noticed that several of the commenters mentioned that they were part of a combined planning, zoning, and the wetlands commissions. The thing is, if you are a combined agency, you have to make sure that you're wearing the proper hat when you're voting on a particular application. If you are acting in a planning function, you've got to consider planning regulations. If you're acting in a wetlands function, you've got to consider wetlands regulations. You can't mix and match, and you have to make sure that you're keeping them separate. There have even been a couple of superior court cases that have suggested that if an application is being filed to an agency that is a combined wetlands and zoning agency, that separate applications have to be filed in those cases. So there is some Supreme Court, there's at least one Supreme Court case that takes a different view of that, but the superior court cases haven't focused on that. So at this point, assume that every agency or each combined agency should be keeping a separate file for each of the functions that it performs. Training of at least one agency or staff member, it doesn't say one, but it should. Training of at least one agency or staff member is theoretically required. I say theoretically, that's what the statute says. One agency member or staff member is supposed to be trained under the state's inland wetlands training program, but there's no impact on the agency's decision if there are not. The statute specifically says it won't affect an agency's decision if that training doesn't happen. Distinguish that from the inland wetlands agent. The statute says that the agent may issue permits for certain types of minimum impact activities in the upland review areas if they have the proper training. And unlike that other statutory section, it doesn't say that their decisions will be upheld even if they don't. So I would assume, because the legislature or the courts typically view different statutory provisions differently, they say that if the legislature said one thing for one aspect and not the same thing for the other aspect, they meant different results. So I would assume that an agent who does not have proper training probably cannot lawfully issue those minimum impact permits from the Wetlands Commission. Now, training of anyone receiving a permit from the Inland Wetlands and Enforcement Officer, I'm trying to get rid of my picture here so I can actually see what it. All right. Anyone receiving a permit from the Inland Wetlands Enforcement Officer must publish a notice within 10 days. Any person, quote unquote, may appeal the permit to the IWWA within 15 days after publication. And notice that's different from most types of appeal provisions which require aggrievement. This doesn't require aggrievement. It says any person can appeal that permit to the Inland Wetlands and Watercourses Agency within 15 days after publication. It also says that that appeal must be considered at the Inland Wetlands and Watercourses Agency's next regular meeting that is no earlier than 3 business days after the filing of the appeal. So if the appeal is filed 2 days before the agency is going to have its regular meeting, then it can defer the consideration to the following meeting. But if it's submitted 4 days in advance, then the agency has to act on it right away. It's important to understand how wetlands are defined in Connecticut law. They're defined exclusively by soil types.
poorly drained, very poorly drained, alluvial and floodplain. And I would ask those of you who are in the wetlands function to really try to understand what those statutes mean. Very, very different from the federal wetlands definition. First of all, federal wetlands definition requires consideration of hydrology and vegetation. You have to have a soil basis for the classification. You have to have a hydrological basis and a vegetative basis. You don't need that in Connecticut. You only have to look at whether the soil is poorly drained, very poorly drained, alluvial or floodplain, as those factors have been defined by the Natural Resources Conservation Service. Now, poorly drained and very poorly drained may not mean what you think they mean. It sounds, if you're listening to them, like a clay soil which passes water very, very slowly because it's very thick soil is going to be poorly drained or very poorly drained. But that's not what the statute means. That's not what the definition means. In the Natural Resource Conservation Service defines a poorly drained or very poorly drained soil by how close the water table rises toward the surface of the ground on a seasonal basis. Typically, if the water table on a seasonal basis gets within about a foot of the ground surface on a seasonal basis, then it can be defined as poorly drained or very poorly drained. So you can have a gravel soil, soil that passes water very quickly that is poorly drained because it's in a location where the water table is within a foot of the surface on a seasonal basis. And those typically occur on the very, very close to rivers or very major stream courses. There will often be sand and gravel soils that pass water very quickly when they're dry, but if the water table is very close to the surface because they're near a river, then they can be poorly drained or very poorly drained. So it's not intuitive what those definitions mean. By contrast, you can have a clay soil where you could pour a bucket of water on it and it could sit on the surface of the ground for 12 hours or something like that before it sinks through. And it's not poorly drained or very poorly drained because the water table is very, very deep in the soil. Alluvial and floodplain soils are both the same kind of thing. That's when a river has overflowed its banks frequently enough to leave a residue of river deposited sediment on the soil surface, and enough of a residue that it's distinctive. When you dig a hole in the ground, you can see that layer of river deposited material. So that's how wetlands are defined in Connecticut. And because they're not considering the hydrologic or vegetative function, the wetland soils in Connecticut are a larger group than wetland soils under federal law. If you have a federal wetland, it's almost guaranteed to be a state wetland. It's not true in reverse. And that's why when you're considering wetlands applications, the important thing to understand is what is the function of this wetland? How is this wetland acting in a hydrologic capacity, in a vegetative capacity, in a wildlife nourishing capacity? How is it relating to those important functions? And that's what we'll be talking about in just a little bit. Now, water courses is a much broader definition. You can see it here: rivers, streams, brooks, waterways, lakes, ponds, etc. There have been a number of court cases that say in order to define wetlands, you have to be a soil scientist, because they're the only ones who can really determine on a professional basis whether a soil is poorly drained, very poorly drained, alluvial, or floodplain, as the Natural Resources Conservation Service determines it. Water courses are different, though. Those can be determined by normal people, by you and me, because we can all figure out what a river is, what a stream is, what a brook is, even a swamp. We can generally figure out what that is. So water courses does not necessarily need to be determined by an expert. Intermittent water courses are a little bit different because an intermittent water course has to have certain technical criteria. So if you're trying to decide whether something is an intermittent water course, you probably should have a soil scientist or other naturalist, a professional, be able to identify those characteristics. Okay, what is a regulated activity? Now, this is defined by state law. You can't redefine it in your regulations because this is a term that's defined by state law. any operation within or use of a wetland or water course involving removal or deposition, etc. It's a very broad definition, and in very early cases involving the Inland Wetlands Act, the Supreme Court determined that it can also, a regulated activity can also occur outside the boundaries of a wetland and water course if it will have an impact of altering or polluting that water course. You see those important words there. All right, so let's talk about those upland review areas. They used to be known more frequently or primarily as buffer areas in the early days, but the Department of Environmental Protection, now called DEEP, preferred the term upland review areas, so that's kind of what everybody is calling them now. I still like buffer areas myself. But understand that the purpose of any regulation in buffer areas is to protect the wetlands and water courses. It's not to protect the upland review areas. It's fine to say, you know, to consider whether an impact on an upland review area will occur, as long as you're connecting it to an impact in the regulated area itself. For instance, the courts have said, if you're considering an impact on a certain type of wildlife that lives a large part of its life outside of a wetland or water course, can you consider that? And the Supreme Court has said you can consider it if it's in connection with an impact that that animal has on the wetland or water course itself. So if the loss of those animals in the upland area will have chemical or physical impacts in the wetland or water course itself, because those animals perform a physical or chemical function that would be lost in those areas, then the agency may consider those impacts. So that's the River Sound development case. I said the Supreme Court, it's actually the appellate court. The best practice is to specify in your regulations the extent of the upland review areas that you're going to be considering and the activities to be regulated within them. There were a couple of cases that I cite there, Prestige Builders and Three Levels Court. They're also cited in your materials that are a little bit contradictory. The Prestige Builders case suggested that you really have to be fairly specific about when you want to review something, an activity in the upland review area. The Three Levels Court case kind of backed away from that and said, well, we'll allow some general language about when you're going to review something in the upland review area and when you're not. The concern that I have, though, is from the standpoint of being clear to the applicant and being clear to the public as to what you are going to be looking at, what things you're going to be looking at. It's better to say, for certain types of activities, we're going to be considering them, you know, within 10 feet of the wetlands or water courses, within 100 feet, within 300 feet. There's even a case that says you can consider them if they occur anywhere on the property. But you should put that specifically in your regulations. When you're dealing with upland review areas, the more specificity you have with regard to what you're regulating, the better. The Supreme Court authorized the outright prohibition of certain types of uses by a 3-2 vote in a case called Lizot versus Conservation Commission 30 years ago. Because that case was such a narrowly decided case, it's unclear whether the court would uphold that today. And I would also point out that actually the function that the commission was trying to protect in Lizot was groundwater, which, you know, it's questionable whether today the Supreme Court would say that the Wetlands Commission has any business considering an impact on groundwater, except as that relates to what might happen in the wetland or water course itself. So I'm mentioning the case because it's out there, it's never been distinguished, but since many subsequent cases have overturned denials based on the lack of concrete evidence of harm, and Lizot is talking about a prohibition of activities without any specific demonstration of harm, I'm not sure that that case would be upheld today, but it's still there, it hasn't been overruled yet. Exemptions are set forth in section 22A-40 of the Connecticut General Statutes. And again, because that's statutory, a commission doesn't have any right to limit them. Agricultural uses are the broadest exemption. Homes for which building permits were issued before July 1 of 1987. Well, you know, that exemption is pretty well extinct. Boat acreage or mooring, residential accessory uses, but that does not apply to most in-wetlands activities. It talks about most activities within the buffer area because it says that it doesn't affect activities that may cause deposition or extraction of material from wetlands or watercourses themselves. Certain water company activities, a very specific one, removal of debris from pre-regulation, pre-1974 drainage pipes on residential property lacking hydrophytic vegetation. So you know that somebody went to their legislator and asked for that to be put in and got it done. Withdrawal of water for fire emergencies. And then there are certain non-regulated uses in subsection B, including conservation, recreational activities, dry hydrants for firefighting purposes. And those are the kind of activities that you kind of go, well, duh. You know, if it's conservation and recreational activities, yeah, they're probably not going to cause a lot of harm. So those are probably not exemptions that you have to worry about very much. But there they are. Okay. Procedural highlights. Because you're going to be hearing a lot about procedure later in the afternoon, and again, I cover it much more extensively in the materials in your book. I'm not going to go over all of the procedures here. I'm going to go over the highlights. Many of the procedures that you're going to be hearing, the general procedures that are going to be talked about later in the afternoon, also apply to inland wetlands. So I'm going to point out a lot of the differences. For regulated activities, no hearing is mandated. That the statutes say you shall not have a hearing unless you either determine, that's the statutory word, that a proposed use may have a significant impact on wetlands or watercourses, or you receive a petition filed by at least 15 adults who are resident in your community, no more than 14 days after the date of receipt, or the commission finds that a hearing would be in the public interest. There is no case yet on whether holding a hearing in the absence of an express determination or finding is a valid basis for an appeal. It seems very unlikely to me that it would be, but the point is, if you haven't gotten one of the petitions that qualify, you probably shouldn't have a hearing unless you make that finding on the record, just so that that issue goes away. You don't want to have that issue hanging around, even though I don't think it would likely be successful for the appellant. Notices, hearings and hearing decision notices must be published in accordance with 8-7D. Notices of certain applications must be sent to clerks of abutting municipalities in accordance with the same statute. As was discussed earlier today, the legislature is considering currently allowing website notice in lieu of newspaper notice, but that hasn't been made yet. And of course, while the governor's emergency orders are still in effect, website notice, town website notice is still an allowable form of notice for most types of meetings. Copies of proposed regulatory or boundary amendments must be filed with the municipal clerk at least 10 days before hearing. And I say that's jurisdictional, meaning that if you don't do it, that will make your decision ultimately void if somebody challenges it within a year. Proposed amendments must be filed with the DEEP at least 35 days before the hearing. That's probably non-jurisdictional. The courts have generally said that notices that are supposed to go to specific people are not jurisdictional. Only the people who didn't receive it can complain about it. Applications for uses in water company watersheds, the applicant must give notice to the water company within 7 days of the application if the water company filed a watershed map in the land records and with the agency. If regulatory or boundary amendments are approved, a copy must be filed with the municipal clerk before the effective date. Again, that's jurisdictional. And with the DEEP within 10 days after adoption, that's probably non-jurisdictional. Miscellany, the agency may be asked to review subdivision applications for property having wetlands or watercourses, even if there's no regulated wetlands activity that would be involved. A report should be provided to the Planning Commission, even though I'm sorry about the typos, even though the agency is not deciding on an IWWA permit. What that means is, even though there's no regulated activity, the agency is still free to comment to the Planning Commission about whether or not they think the subdivision in its currently proposed form may have some kind of an impact on wetlands in the long run, because it will force, perhaps because it will force houses to be built in a certain area or something like that. in other words, the agency can anticipate that there may be regulated activities that are going to be made necessary by the format of the subdivision, and you can comment on those, even though you're not actually going to be deciding a regulated activity application prior to the subdivision approval. But you should definitely make that report. The Planning Commission has to wait for it before it can make its decision on the subdivision. Applications need not comply with changes to regulations made after submission, but they may be required to comply with changes in state law. Inland Wetlands and Watercourses agencies may establish a fee sufficient to cover the reasonable cost of reviewing and acting on the application or petition, including all of the things I mentioned. You can see that in the materials as well. I'm flying through this because I can see my time going by so fast. This is so hard to do in 30 minutes. All right. Here are the factors that you have to look at. They're in 22A41. So look at that statute. It lays them all out for you. What I've done in this slide is I identified in bold the words that I want you to really focus on when you're looking at that statute. What's the environmental impact on the wetlands and watercourses? Again, not on the buffer areas, not on the upland review areas, on the wetlands and watercourses. You're supposed to consider the applicant's purpose for and any feasible improvement alternatives to the regulated activity. Which alternatives would cost less or no environmental impact to wetlands or watercourses? So this is part of the balancing test. What is it that the applicant is trying to do? What is the impact going to be? Is there any way of accomplishing the applicant's objectives without compromising unnecessarily the wetland and watercourse itself? We'll talk about feasible improvement alternatives next. Relationship between short and long-term impacts, irreversible and irretrievable loss. What is going to be lost to the wetland or watercourse that won't come back? Mitigation measures, which may be considered as a condition of issuing a permit, in the following order: restore, enhance, and create productive wetland or watercourse resources. So the first thing you want to do under A is prevent or minimize pollution or damage, maintain or enhance existing environmental quality, but if you can't, restore, enhance, and create productive wetland or watercourse resources. The character and degree of injury to or interference with safety, health, or the reasonable use of property, which is caused or threatened by the proposed regulated activity. So that means something a little bit different than you automatically think. This is not the applicant's reasonable use of property that you're talking about here. It's somebody else's reasonable use of property. Is what the applicant proposing to do going to interfere with the reasonable use of property? You consider the applicant's purpose up at number 2, but then you consider impacts on other property perhaps, or even on future uses of the property itself under 5. And then impacts of the proposed regulated activity on wetlands and watercourses outside the area for which the activity is proposed, which are made inevitable and which may have an impact on wetlands and watercourses. So again, the impact on wetlands and watercourses is key. Feasible improvement alternatives. Feasible means able to be constructed or implemented consistent with sound engineering principles. It means that you can do it. I mean, there's no engineering reason why you can't do it. If I can use a bad example, I'll use the COVID vaccines. A year ago, they weren't feasible. Today, they're feasible. Okay, so it's a very, very broad definition. If you can do it today, if it's recognized as a technically viable alternative, it's feasible. But prudent is much broader. Economically and otherwise reasonable in light of the social benefits to be derived from the proposed regulated activity, provided cost may be considered in deciding what is prudent, and further provided a mere showing of expense will not necessarily mean that an alternative is imprudent. So it's a very broad balancing test again. And basically it's saying commissions can use their good judgment here. If the agency held a hearing after finding that the proposed activity might cause a significant adverse impact on wetlands or watercourses, it may not issue a permit unless it finds that a feasible and prudent alternative does not exist. And if the permit is denied on that basis, the applicant or the agency must propose on the record in writing the types of alternatives which the applicant may investigate. However, the burden remains on the applicant to prove that such alternatives do not exist. Applying the standards, applications may not be denied because of generic risks. The nature of the risk and the probability of harm must be reasonably supported by adequate and usually expert evidence in the record. In the Lord family case, there was a denial of an application to build a bridge because the commission in that case said, well, we all know that cars crossing the bridge are going to dump oil and stuff into the river under the bridge. And the court said that's not enough. That's basic speculation. It's lay speculation. There was no technical evidence that there was going to be a specific harm to the wetlands. Same thing in the River Bend case. No specific evidence that would be any specific type of harm. Nevertheless, the applicant has the initial burden of supplying the evidence that the proposed activities will satisfy the criteria. For comparing these two ideas, look at 3 levels, court versus Conservation Commission, and again, it's cited in the materials. The court held that the commission's first reason for denial, risk of harm, was not adequately supported by the record, but its second decision, the applicant failed to supply the required information, was valid. Okay, so a good case. Agency may not disregard expert testimony in the absence of countervailing testimony. We've heard that before. Broad authority for conditions of approval. Read them in the statute. I'm running out of time fast here, so look at 42 AD. They may not be made personal to the applicant. They run with the land. Whoops, sorry about that. Okay, I can't read the first one. It may include bonding requirements, may be subsequently removed or modified if proper evidence for doing so is provided. Off-site mitigation may be acceptable at least where the applicant agrees. Okay, the first one, okay, I'm sorry, I couldn't read it because of something on the top of my screen, but what it says is you can't make a condition of approval if the applicant has to provide evidence that it should have provided to show that it satisfied the conditions in the first place. In other words, you can't say, yeah, we'll approve it and let you come back and prove that you had the right to it later. The duration of permits, look at those statutes. There are some new statutes that are being proposed that might extend those. Enforcement orders, there's enforcement possible by the Inland Wetlands Enforcement Agency. Review those procedures under 22A44 in court proceedings. Fines can be issued under 42G, but they must be established by the ordinance. It's not clear whether they may be per day. The statute doesn't say so. And enforcement by the IWWA, it may suspend or revoke a permit if it finds after giving notice to the permittee of the facts or conduct which warrant the intended action. What I'll summarize this to say, if you want to take specific action as an agency to suspend or revoke a permit, you have to give notice to the permittee of what you're complaining about, what you think the applicant has done that deserves it, and you must give the applicant a hearing. Look at 22A, 42A, subsection D for that. Appeals are covered by the statute. For appeals of decisions for which notices are published are available, must be commenced within 15 days. Court may modify a decision if it finds that a taking would otherwise result. It's unclear whether an appeal may be taken from an inland wetlands agency's decision on an enforcement order because publication is not required. And there are 2 conflicting Superior Court cases on that. Oh gosh, I'm out of breath and I'm also out of time. So thank you very much.
Frank, it's done.
It's Mike.
No, it's a lot.
Is that going to be available on the town website, Musa? On our website?
It's actually available. And this is the seminar that, if you remember, that every other year they provided Wesleyan University from Connecticut Bar Association. The entire presentation of that day is available on Connecticut Bar Association website.
Excellent. Yeah, that was very good.
Interested, yes.
Much to comprehend in a short time you gave it.
Yeah, and also we will get to that point that I also send you a hard copy of this presentation.
Yeah.
The material that he was referring to, that is the one that actually I expect that all the commission members take some time to read those, and then we can discuss it in future if you have any question.
Thank you.
Thank you, Musa. Communications and bills, right? Inland wetlands and water course.
I did.
Regulations by Attorney Michael Zaga.
This is the one that I sent it to you.
Yeah.
And you need a motion to accept and file.
Make a motion to accept and file item number 1 under communication of the bills in the wetland watercourse regulations. Michael Ziska.
Second.
Motion made and seconded. Any questions on the motion? Secretary will do the roll call.
Craig Pollard.
Aye.
Tom Murphy.
Aye.
Myself, aye. Pierre Moran.
Aye.
Luigi Cavallo.
Aye.
Charles Belvo.
Aye.
Motion carries. Reports from officers and committees. Chairman report. Moose, is Mark on there?
Yes, Mark is on.
Can he can get unmuted and hear us, or? I just have some questions for Mark.
Mark, are you there?
Self-muted.
Mark? I can see his name on the list, but
right.
Maybe he's muted.
Well, maybe we can bring to your attention, Moose, and then you can do what you got to do. The last couple of weeks I've been working the vaccination side of town hall, and somebody that came in to get vaccinated took me down to the lower parking lot to show me the, I don't know what you call it, a retention pond or something in the back over there. It's full of water. It's all green. There's no fence around it. I just
next to the new parking lot.
Right, by the new park. It looks like
it's supposed to be a rain garden.
It's supposed to be a rain garden, but it's, I don't know how deep it is. It doesn't look very secure and finished and done. Could you?
Yeah, we'll look at it, Mr. Chairman.
We will look at that.
Right. I mean, there's people wandering around in there and stuff. So maybe you could give a report back.
Okay.
And I had asked Mark in the past when we had this FOI information that members from the commission requested either access to the town, have our own town email or a phone. Can you?
Actually, I talked to Mark about this today, and Mark said that he talked to the town manager's office.
Right.
And they believe that it's a good idea. Probably they will provide an email, a town email to all land use commissions and other commissions.
Okay. You think
they're working on this. We will let you know what happens with it.
All right. So
great, thank you.
Put something in writing to us.
Okay.
And can we check on the status of our alternate members? I've asked in the past. I've never seemed to get an answer here. I'd like to have new members come on, or I don't know what the proper way is to.
Okay, I will check that too, because you sent a letter to the town manager's office.
Right, I never got a response on that either.
Okay, I will check that with the town manager's office.
All right. That's all I have. To report from bylaws review subcommittee.
Well, Stan had sent me a reminder last week. I sent an email out to the committee members, did not hear back from them. I did not follow up with them. It's my fault. I was just busy this week. We will have a meeting and a report by our next meeting. I will communicate most likely through cell phone, so everybody's aware of it, that I'm communicating with commission members on the cell phone to set up a meeting.
Right. Okay. Thank you. I don't know if we need a motion on 1 and 2, Musa, or no?
No, Mr. Chairman, these are just reports.
All right. All right. And then we have reports from staff, agent determination, application 2021-3 of the town of Watertown Public Works for emergency cleaning and removal of debris from spillway intake structure at Merriman Pond at Northfield Road. I went by there. It seems like it's been done, and the riprap was left there, and a chain was installed for, looks like, fire department access. Correct, Paul?
Yeah, that's correct, Mr. Chairman. They were concerned about getting to the water, so they're going to install probably a lock on that chain or something that they can get at easily. So that is the purpose of the end purpose of the cleaning and leaving the riprap there, and removing the fence section. Yep.
Thank you.
This is the application that the last meeting you authorized me to issue the permit due to the emergency situation.
Correct.
Yeah, they couldn't wait like 2 months for you to decide. I already approved it. Yes. And these other two, Mr. Chairman, item B and C are also some minor activities. One is a shed and the other one is a swimming pool, above ground pool that I already approved.
Okay, so just make a motion for all three.
You don't need a motion for this.
You don't?
No.
No.
Thank you.
Staff agency.
Item D.
And D is that review checklist.
Did you get a chance to look at that checklist that I sent it to you with the packet?
Yeah,
a little bit.
So is this something new, or just can you run of how this was developed and what's on it, or so we know?
From now on, for each application, you will receive one of this filled by me and probably Paul.
Yes.
Right.
I will do the first section of it that is related to the applications and activities and all those other requirements. And then when it gets to the technical part of it, all the engineering designs and stuff, I will give it to Paul to fill up that other section of it. In case if you see that something has to be added to this checklist, please let me know.
Okay.
But other than that, in future, you will receive one of these checklists with every application.
Right, and you're going to sign off on each line or put your initials, or how is that going to be approved? Or
and you see there kind of like question that if that is provided yes or no,
right.
If that is sufficient yes or no,
right.
If there's anything missing, we will let you know.
Okay.
Then you can have a decision. And if you determine that due to this checklist that some of the information is missing, right. You can deny the application that this is an incomplete application.
Right.
Perfect.
Yes.
Perfect. That's it.
Are you just looking to make sure somebody's taking responsibility for signing off on it? Somebody like Mark or somebody, top on down? Is that what you meant?
Well, whoever takes the application is going to fill this out.
Got it.
Right, because it's, it seems like, I don't know what happens, but like this application of 2021-7, seems to be confusion what the applicant said and what the office said. I don't know how that, he's a builder and I don't know how that happened. That's the stuff I like to see stopped.
Yes, I can explain to you what happened. The applicant submitted an application for a zoning permit.
Right.
That doesn't mean that that is a permit until we issue the permit.
Right. Well,
he submitted the application, then he said that he wants to put the silt fence and anti-tracking pad and stake out the location of the foundation. That is required.
Right.
Like he went there, clear cut the whole thing. And I went there and said, hey, you can't do that.
Right.
And I stopped him, and then I noticed that there is some regulated activities.
Right.
That there is wetlands on the property.
Right.
And that's why I told that you have to come to the commission to get a permit for this.
Right. I mean, this isn't his first game. To me, there's no excuse for that, but whatever.
Yes, no excuse. No, I agree.
Right. Anybody else from the commission have any input on the checklist or?
Pierre Moran here. I have a question that pertains somewhat to this High Meadow Fern Hill application. On Echo Lake Road, there is a piece of property that was for sale. Don't know if there's been an application put forward for anything on it, but it was designated low income. It was approved for low income. It's across from Burton Street.
Right. Right. Yep.
They're cutting all the trees down up and around there. Has there been any application filed for that property?
Yeah, they didn't come to the Wetland Commission because there was no wetland on the property, but they got their permits from the Planning and Zoning Commission. They have permits to do that, yes.
To do what? To cut the trees down or to build a
trees and start building?
So what's going to be built there?
I think there was some condominiums and some of them, like 10% of them will be low income residents.
That's what was the intent. I don't know.
Affordable housing, like some of them.
But Musa, when they go in, I thought it was still under the commission when they go in and cut a certain percentage of the trees down. It still came before us, no?
I thought so too.
No. On private properties, no. On town-owned property under your Conservation Commission jurisdiction, you have the right to control the town properties, but not private properties.
So they can clear cut it without any do with wetlands.
If they have a permit from the Planning and Zoning Commission to build something, yes, they can do that.
Okay. But even though when they cut down all the trees, it destabilizes the ground, but it's not there, right?
I'm sorry, I didn't get your
no,
question.
when they go, I'm just saying when they go in and clear cut it and remove do all that whole hill comes unstable, but that has nothing to do with wetlands, correct?
No, if there is no wetlands or there is no wetland regulated activities, you have no jurisdiction over that.
Okay, thank you.
But they got a permit from the Planning and Zoning Commission to remove a significant amount of material from there in order to make the lava built on.
All right, so
they have their planning and zoning.
And that's like where a mining permit goes through planning and zoning?
Yes.
Okay. All right. Public participation. Anybody from the public?
Mr. Chairman, before you get to that,
yes, sir.
On the item D, is the checklist is okay with the commission that I use it from now on?
Yes.
Or you want to let me know to add something or?
Well, I assume it went through your department, zoning and engineering?
Yes.
We spent a considerable amount of time on this, Mr. Chairman. We think it's pretty comprehensive. I think it's comprehensive and covers just about everything we can think of. So.
Right.
If we notice something that we should add, we will add it. Yes. But it is okay with you.
I would make a motion to start using this application checklist. And if we find any changes we'd like to make at a future date, we do so.
Yeah, it'd be an evolving document.
Is that a second time?
Yes.
Motion means any questions on the motion? Roll call, please.
Charles Beliveau.
Aye.
Pierre Moran.
Aye.
Tom Murphy.
Aye.
Luigi Cavallo.
Aye.
Myself, aye. Craig Palmer.
Aye. Motion carries. Okay, public participation. Anybody from the public?
Catherine?
Anybody?
No hands raised.
No hands raised, Mr. Chairman.
Make a motion for adjournment at 8:08.
Make a motion, we adjourn.
Second. Roll call. Ned. No. Thank you. It was a good meeting.
Good night, everybody. Thank you.
Thanks.
Good night.
Bye.